A big hello and a warm welcome to all the participants and attendees of this conference. As you know from my introduction, I have a background in law and public health, although I now work explicitly on public health as a researcher, as an advocate, and as an activist for rights of patients as well as for rights of healthcare workers. So starting with, when we talk about human rights, what are human rights? These are rights which are inherent to all human beings, regardless of race, regardless of gender, regardless of sex, nationality, ethnicity, language, religion, or any other marker that is used to classify human beings. These rights are developed through authoritative interpretations of international laws, of regional treaty laws, and these rights lay down the obligations of governments to act or to refrain from actions in order to promote the fundamental freedoms of all individuals and groups. The foundation of this body of law is contained in the Charter of the United Nations and the Universal Declaration of Human Rights, which go as far back as 1945 and 1948 respectively. Now these rights continue to be expanded, and the charters and the international instruments that we have, which lay down these rights, continue to be expanded in interpretation through treaty monitoring bodies and through councils which are set up under these international instruments themselves. Now, international human rights bodies have played a very significant role in codifying and monitoring violation of human rights in the context of sexual and reproductive health rights. Historically, however, there has been an absence of recognition of violence, that women face during childbirth, while getting facility-based care in global human rights instruments. The Universal Declaration of Human Rights, for example, recognizes motherhood as a condition that is entitled to special care and assistance. The Convention of the Elimination of All Forms of Discrimination Against Women, or the CEDAW, which is a key convention that addresses protection of women's rights, does not address maternal rights or violence faced by women, during facility-based care. Recently, however, we have seen an increasing application of human rights standards to maternity care, with much of the focus being on issues around access to care or coercion in care provision, and not so much on the quality of care that women receive or the mistreatment that is faced by women during childbirth. In 2014, the WHO attempted to fill this gap by releasing a statement on mistreatment of women during childbirth and the associated rights violations. This was the first attempt to recognize the violation of rights, of women during facility-based childbirth, which is a marker of quality of care, and poor quality of care and mistreatment of women during care acts as a disincentive for women to opt for facility-based care. Now, the WHO statement framed the issue of disrespect and abuse as a violation of broadly the right to the highest attainable standard of health, which includes the right to dignified and respectful care. However, different forms of mistreatment, as laid out in the RMC, in the White Ribbon Alliance RMC Charter, do implicate violation of diverse and multiple human rights. A bare reading of the RMC Charter, that has the articles listed out along with the sources of international human rights instruments that these are drawn from, will highlight this aspect. Now, human rights standards are an important accountability tool for recognizing and for protecting the rights of women during facility-based childbirth. And these also assist policymakers in defining disrespect, in defining abuse, in defining mistreatment, and formulating effective interventions, policies, and even laws to address this issue. And thus, there is a definite need to continue documentation of mistreatment in the context of human rights, and expand application of human rights standards as enshrined in different instruments to address this issue. The second important need and challenge that we have really is building effective accountability measures to enforce these standards for individual redressal of grievances, but also for bringing in accountability within systems, so structural reforms. And I think this is an area that countries and civil society often struggles with, that how do you enforce human rights standards that are enshrined in international documents, but are not directly enforceable at the national level. Now, there are essentially two ways that this can happen. One is through human rights litigation at the international level or at the national level. And at the national level, when you engage in human rights litigation, you have judicial interpretation of these human rights standards into existing national laws. Now, we have examples of the CEDAW committee, which had passed two landmark decisions pertaining to sexual and reproductive health rights of women. The first of these being against the government of Brazil, where they had held the government accountable for a preventable maternal death. And the second was, with upholding the right of Peruvians to access legal abortion. Now, these decisions, it is important to note, were not directly binding, but they were useful precedents, and they were useful for civil society to push for greater health system reform and for recognition of women's sexual and reproductive health rights, and to push for greater accountability from the health system. In the instance of national courts, taking the example of India, where I am based and where I work, we have many landmark judgments that recognize, first, the right to health, and this was interpreted under the right to life, which under the Indian Constitution is a fundamental right. And then, there are case laws that specifically also deal with women's right to reproductive, sexual, and maternal health services. And much of this has been born out of legal advocacy and action that has been undertaken by civil society. So we can see that, for implementation of human rights, it is important that civil society be engaged with this at every step. Now, the second way to ensure accountability and enforceability of international standards is through parliamentary intervention and codification of these rights into laws. For example, as we see in the case of Nepal, where the White Ribbon RMC Charter was used, and codified into a safe motherhood law. And this is a significant opportunity for rights-based healthcare service delivery by translating rights not just into policies, but also laws, and thereby bringing in more justiciability to these rights, and attaching greater weight for their enforceability. Now, one of the biggest obstacles to accountability of health systems and pushing for a rights-based service delivery model is, whether there is existence of a regulatory law in the country or not, and the persistence of regulatory bodies to implement these laws where these laws may exist. Now, speaking from the Indian perspective again, in India, we lack a comprehensive regulatory framework to regulate hospitals and to regulate the quality of care that is delivered in hospitals to patients. Of course, beyond just obstetrics and gynecology, in all aspects of patient care, and also, thereby lacking in a regulatory framework to regulate, patient quality of care that is given to women coming for childbirth. And in India, we have seen that there is a failure of existing accountability mechanisms. So we have, one form of regulation has been self-regulation by the profession itself, and we have seen that has not worked in ensuring that patients' rights are protected. And the second aspect is consumer litigation, which individual consumers can initiate when there has been negligence. But I think purely medical negligence does not capture the full range of rights violations that are possible in delivery of patient care, and also it is much harder to prove. And negligence is not the only form of violation of patients' rights. And as we see in the RMC Charter, there is much more than just medical negligence. Now, I know that regulatory, regulation and regulation of the healthcare system in particular is something that sets alarm bells ringing in the minds of healthcare professionals, and it is something that becomes, a difficult conversation to have. But as we have seen during the COVID pandemic, that lack of a regulatory framework actually also hampers the rights of healthcare workers, particularly with regards to five-star hospitals and even with regards to public hospitals. And as we see more and more vertical integration of private hospitals, where large corporate hospitals are taking up and absorbing smaller provider-led clinics and hospitals, and as we also see greater engagement of the corporate for-profit sector in delivery of health services, with public-private partner PPP arrangements with the government. So it does become important to have a regulatory framework that protects the rights of patients and is also is also something that protects the rights of healthcare workers. And we also see that, starting from the fact that the kind of violence that laws recognize, again, the kind of violence against healthcare providers that laws recognize is interpersonal violence from patient to provider, but not from health system to provider. So I think, having a regulatory framework that encompasses some of these international human rights standards can go a long way in protecting patients' rights and also in protecting rights of healthcare workers. To give you an example, in India, we do have a law called the Clinical Establishments Act, which is, an act that provides for registration and regulation of healthcare establishments. However, there are problems with the implementation of this act. One, because the standards according to which hospitals have to be registered, healthcare establishments have to be registered, are not notified. And second, this is a central government law, and in order to be implemented, it has to be brought in at the state level, since health is a state subject in India. So what we see, the standards which have not yet been notified, if you actually go through the standards, we find that, there is an opportunity to integrate some of these rights into the standards and have these, enshrined, as practices which healthcare establishments are bound to do in order to continue to function. And so therefore, when you look at the standards that are provided under the Clinical Establishments Act, we see, that a lot of these include some of the rights that are also mentioned in the RMC Charter. So for example, the right to information, the right to informed consent, the right to, the highest attainable standard of care are all rights that are included, under the minimum standards which facilities have to adhere to while providing patient care. So I think, there is a need to reimagine the way regulation is thought of from the provider perspective, and see how this can be an enabling factor for healthcare providers to practice ethical medicine, and also uphold the standards of their profession and the standards, enshrined under human rights treaties. And how to bring these together. I think for addressing mistreatment, we also need to reimagine the use of remedial legal measures. So, while there is, the classical mode of litigation, I think it's also important for us to see how alternative forms of dispute resolution, such as mediation, can be utilized to resolve individual concerns, and also then use these to inform hospital level and structural level changes, and to resolve disputes, that may arise between healthcare workers and patients at the hospital level, and to implement and enforce, to enforce, long-lasting system-level changes to improve patient care. The idea, I think, of legal measures should not purely just be traditionally adversarial as they are, but I think they need to be more collaborative, and they need to be, they need to inform, not finding a healthcare professional to pin the blame on, but to identify systemic problems and to address these using human rights standards. So I think in the end, I just want to say that 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 human rights and the international law and human rights instruments are extremely important for upholding rights of women. And there are various legal recourses that one can take to sort of integrate them. But I think what's also very important is the continued engagement of civil society organizations and groups, in order to ensure that these are actually enforced and that these are actually implemented. And for this, we require greater cooperation between patients groups, between women's groups, and between providers associations, organizations, and groups. Thank you.